Good afternoon. This is Dave Henry, and welcome to sections 5 and 6 of the Mediation Mastery Series. If you've been with us before, thanks for coming back. If you are new to the series, I would encourage you to go back and check out sessions 1 through 4, which are available on my website, henryadr.com. There is a certain logical sequencing or sort of temporal connectivity to these sessions. We begin with selection of the mediator and timing and authority issues and things of that nature. We move temporally closer and closer to mediation. And today we get right up on the eve of mediation. Then we talk about opening session, and we talk about mediating the business divorce in the second half hour. So the first half hour is countdown to successful mediation, letters in advance, pre-mediation statements, apologies, and opening statements. And then the second half of the second 30-minute session today will be mediating the business divorce. And I think you'll find that interesting because business divorce cases require a little special handling. So let's just jump right into it. The course number, by the way, is listed in the chat. You do get partial credit. It is a 5-hour series, but you don't have to take the entire series. When you go to the Florida Bar website to post your hours, you can select partial credit from the menu. Just put in the number of hours you actually viewed. I would encourage you to see all 5. The idea is if you've seen all 5, you've covered just about everything there is to know about mediation rules, ethics, participation, negotiation, breach, contract formation, intended to be sort of the one-stop shop for all things mediation in Florida. And I hope it serves that purpose for you and your colleagues going forward down the road. All right, so let's talk about countdown to mediation. One of the challenges of mediation is we don't have any rules that tell us what to do ahead of time. Unlike other things, we know what we have to do because the rules of substantive law, the rules of procedure, case law tells us what we need to do in advance of a trial or a hearing or a deposition and what we can do during those things. But in mediation, we really don't have any rules other than the rule of confidentiality. So we have to make up our own countdown, so to speak. We have to make up our own pre-mediation checklist. And I'm a big believer in that because there are things we can do in advance of mediation that will ensure that the mediation goes off well, that we have all the key decision makers, that we're not missing somebody, that we have all the information disclosed. And because the mediation rules are lacking, we have to be sort of self-disciplined and impose these practice habits upon ourselves. And I use checklists to get there. And if you go to my website after this seminar, you'll find a countdown to mediation. I think it's very useful. For some reason, it's not on the website. You can email me at dhenry@henryadr.com, and I'll send you the countdown to mediation. I also have a memo to clients that I use in advance of mediation. It's very helpful. That explains the mediation process and answers 99% of their questions. And that's another useful tool I think you'll find on the website. If not on the website for whatever reason, email me and I'll send you the what is the mediation client memo that I developed, meant to be one size fits all. So the count list or the checklist tells us to do certain things in advance. Who's going to be, and these are going to seem kind of obvious to you, but I can tell you as a mediator, I get into mediations, and once every, I don't know, 10, 15, 20 mediations, we have a meltdown before the mediation begins because there's something that's gone wrong in advance that we could have averted. Like we don't have the right people, right? There should be an insurance carrier up there. They're not there. We don't have a key decision maker. One of the minor co-defendants isn't there. The insured isn't there. One of the parties is not there, but their in-house counsel is there. And we're missing some key people in the equation. And that is fixed by simply emailing the other side in advance of mediation saying, who are you bringing? Here's who I'm bringing. Who are you bringing? And if that list looks right, then good. But if it doesn't look right, then you can have a conversation about it. And it's a very simple thing, but I'll tell you, it doesn't get done. And the reason it doesn't get done, and this is the problem with all things mediation, is because there's no rule, there's no requirement from the court, there's just nothing in our process that requires you to do these sort of things. You have to come up with your own checklist of to-do items, and that's what this seminar is really aimed at doing, is creating this sort of pre-mediation checklist. And every session that we do gives you something else to add to that checklist. And you're going to have a checklist of 10 or 15 things to do before the mediation. And 99 times out of 100, there'll be a non-issue. It'll be no problem. Everything will seem copacetic. But every once in a while, if you do these things, you send out these emails, you have these phone calls, something will flare, something will pop, then you'll be able to address it, hopefully, in advance of mediation, so the mediation doesn't become unproductive, doesn't become a kind of a hot mess at the beginning of the day. So asking, Who are you bringing to the mediation is a very simple email. Here's who I'm bringing. That needs to go out all the time. The next thing I want to know is, how much time have you set aside for this mediation? Everybody assumes, I assume, if you sign up for a 9:30 mediation, I'm assuming, unless you specifically tell me it's a half day, I'm assuming you're available to go all day. Know in advance. How long do people have to mediate? I've been in places where people were gone by 3 or 4 hours. They didn't tell the other side. Another question you want to ask the other side in advance of mediation: are we doing opening sessions? Again, in Florida, the default rule is, well, yeah, we naturally do a joint opening session. We do that, probably 95% of the time. But there are times when you want to dispense with an opening session, right? And so you need to have a conversation about that. You don't want to wait till the morning of mediation and say, well, I'm not having an opening session. I don't want to hear from you, and I'm not going to talk to you. Well, the other side may have spent a good bit of time working on an opening session because there's things that they want to communicate, and it gets very frustrating and annoying, and they've wasted a bunch of attorney's fees if they prepared an opening statement, much less a PowerPoint. So you really need to have a conversation a couple of weeks in advance of mediation. Are we having an opening session? Again, most people don't ask the question because they assume it's going to happen. And then one side, for whatever reason, maybe at the 11th hour, the client doesn't want to be in the room with the other side, or has a hissy fit, or whatever it happens, and all of a sudden we're not having an opening, and we're going to have an hour conversation about what do we do now about that, when really we could have addressed that in advance. Or we have people coming to the mediation that we didn't anticipate. There's some non-party that they want to participate. Maybe it's a friend, maybe it's a relative, maybe it's an expert, maybe it's a consultant. And then there's a big hoo-ha in the morning about who's there. Well, the rule is you can bring anybody you want to. But again, you should have a pre-mediation communication about who are you bringing to the mediation process so we can vet all these issues. Ultimately, it's not the mediator who decides, it's the parties who decide who comes. I don't have the authority to kick somebody out of the mediation. If you want to bring someone and the other side doesn't like that, you either got to reach an agreement or you got to seek relief with the court. I'm not going to be the arbiter, I cannot be the arbiter of who attends the mediation process. And I've had that come up as recently as a month ago. So I know this happens unless we have some pre-mediation communication. The other thing I want to talk about is, so we talk about participation by non-parties, who's going to be there. Getting a mediation statement to the other side, I think, is really important to put on your to-do list. It's not enough to send a mediation statement to the mediator. I want to encourage you to send a pre-mediation communication to the other side, setting forth how you see the case. What are the challenges? It doesn't need to be legalistic. In fact, I don't think it should be. It should be written for the parties, not the lawyer, written for the eyes of the other side, because this is your one and only opportunity to speak directly to the other side unfiltered. You don't get that opportunity. See, the whole problem with litigation is it silences the clients. We don't let the clients talk to each other. We don't talk about the central problem, which is how we're going to resolve this case. The litigation doesn't allow that conversation to take place. So when we come to mediation, it's the one chance we have to speak directly, unfiltered, to the other side. That's a hugely valuable opportunity. So when I see people who don't send a pre-mediation statement to the other side, I view that as a wasted opportunity. Here, don't assume the other side knows your case or their own. I can't tell you how many times I've had this conversation, particularly with plaintiff's counsel, but defense counsel too. I say, do they really understand your case? Do they understand what your damages are? Do they really understand the liability? And vice versa to the defense. Do they really understand how bad their case is if they're talking about the plaintiff's case? Do they really understand what your defenses are going to be? What are your factual defenses? What are your coverage limitations? Don't assume. It's the first thing we used to say in law school, right? Don't assume. Don't assume the other side knows your case. If it's a claim adjuster, that claim adjuster may have lots and lots and lots of files, and yours is just one of many, and they haven't been paying that close of attention to anything. So your pre-mediation statement 2 weeks before gets their attention. It's like turning on the stove. It's heating up the file. That's what you want to do. You want a hot file. And hot files are created when there's communication related to the file. The other good thing about sending a pre-mediation communication to the other side, it doesn't have to be a long letter. It doesn't have to cover, everything from soup to nuts at the beginning of the world. It could just be, it's a BI case. Here's what I understand to be the key liability issues. Here are my damages. Here's my meds. Here's my lost wages. Here's my liens. And here's why I think you ought to settle the case, and why my lady or my guy makes a good witness, and why I think you should pay him some money. It doesn't have to be anything long, but it gets the attention of the claims representative, and that's what you want to do in a BI case. And in a business case, it's even more important to get that information out, because the other folks may be distracted. They may be doing other things, not paying attention. Maybe the information hasn't been filtered as well. See, one of the things you have to be careful of is that, is the lawyer for the other side an accurate reporter of actually what's going on in the litigation? And that's not always the case. Lawyers sometimes shade the information because they have optimism bias. They have optimism bias. So it's very common. Lawyers are just like any other people. They're not immune from optimism biases. So they may filter out some of the bad information and keep the good. Well, if you're a plaintiff's attorney, you want the defense to know all the bad information about their case. And so the pre-mediation communication, to me, is the most vital piece of the whole pre-mediation prep, because what it does is it helps manage expectations. It helps inform the other side. It introduces some themes that you're going to then hark back on, and I, as the mediator, are going to hark back on later in the case, right? Later during the mediation. So you're going to introduce some kind of key swing thoughts, some ideas, some concepts, some key bullet points, so to speak, in the summary, in the mediation statement, and then you're going to reiterate those during the opening. Why should opening be a disclosure of new information? It shouldn't be, because if you're a plaintiff, the defense won't have had enough time to react to it. If you're a defendant, you may offend the plaintiff and put them off in such a way that they're not really in a good position to negotiate. So you don't want the mediation to be a revelation of surprise. That is the worst thing that can happen in mediation. You should have a pretty good idea of what the other side's position is, what the strengths and weaknesses are going in. If there's big revelations, any mediator will tell you you're probably destined to impasse, or you're going to have a really hard time overcoming those new and significant either hurdles, if there's a defense raising them for the first time, or if the plaintiff, there's new damage items, for example, that haven't been disclosed. All sorts of things like that can be an issue. So pre-mediation communication might also highlight the fact that there should be another party to the case. Maybe the plaintiff's got it wrong, and the person or the entity that they're talking about isn't you, but somebody else. Maybe it's a construction case, and they're making allegations about certain issues, and that's not my scope. That's somebody else's scope. So those sorts of things can happen. It looks like I may have had an internet interruption here for just a second. I apologize if I went down for just a second. Looks like it's stable now. Appreciate your patience there. So pre-mediation communication, memo to the other side, written in a cordial tone, written to the party. You want the other party to read it. So write it for the other party. Don't write it for the lawyer. Write it in digestible, ordinary language. Here's what I'm concerned about. Here's what you should be concerned about. Here's why we need to try to settle this case. Okay, so you've done that. You've got the pre-mediation statement. You've communicated with the other side about who's going to be appearing. You got a pretty good idea who the attendee list is going to be. You've decided you're going to have an opening session. When would you dispense with an opening session? When wouldn't you have an opening session? A handful of times we dispense with, if, and not because, oh, well, they know our case and we're saving time. Wrong. That's not the right reason for dispensing, because they don't know your case. Don't assume that they do. And if anything, you want to see the interaction between a lawyer and a client. And is this client paying attention? Does this client look like a client who's in for the long haul? You get information during the opening session. Do they make a good witness? Are they focused? Are they paying attention? Do they look unsophisticated or sophisticated? You get information. So I want that opening session. I want to see that other side in the mediation process and how they're reacting to the stress of that situation. But if you don't do opening, you might dispense with opening if you have really contentious, salacious allegations. I've had cases involving clergy abuse, pastoral abuse, sexual harassment, things of that nature, where you certainly don't want the harasser in front of the plaintiff. You don't want something that's so volatile. If maybe it's a deceased, it's a bad baby case in a medical malpractice, the parents don't want to eyeball the doctor who's responsible. I can see that happening. So there are a handful of times, but it's a very narrow set of cases, I would submit to you. Just because they don't like each other, that's not a good reason not to have an opening. In fact, that's a good reason to have an opening, because one of the things that I use as a mediator is that uncomfortable feeling. And I go to the parties in caucus, and I go, how did you feel like, how was that sitting with Mr. Jones for half an hour in the opening session? Oh, I hated it. Well, yeah, you're supposed to hate it, right? Well, I go, well, and I come back to that later in the mediation. I go, remember how you told me you didn't like the opening session for half an hour? Well, if we don't get this case settled, you're tied to the hip to this guy for another 18 months of litigation. And then they kind of get that, right? The need to be undone, to be divorced from this problem is highlighted when you force them in the same room together, right? And so I kind of like putting the people in the room together because it can be uncomfortable, particularly if they know each other in advance of litigation. If it's a BI case, if it's a normal, car accident case, there's usually not a big deal there. But again, that's a conversation point you need to have with opposing counsel in advance of mediation, not the day of, because you could definitely frustrate somebody and get somebody very upset if they were anticipating that they would have an opportunity to talk to the other side. And you shouldn't necessarily limit your client's access because you may learn something that you didn't know. I think it's pretty important. So, okay, we're having an opening session now. Let's talk about apologies for a second. Apologies are underutilized. Apologies are very good. They don't cost you anything. They're simple, they're short, they're sweet, and they set everything off on the right tone. If you're clearly at fault, if you have clear liability, there's no reason in a mediation not to offer an apology. You say, well, it's going to inflate the plaintiff's value of the case. Nah, it doesn't really. It's not true. The case is worth what the case is worth. Apologizing for it just sort of sets a moral frame. It's not a financial frame. It's just a moral frame around what's going on here. We acknowledge that we have a problem. We did something wrong. Saying that goes a long way in the plaintiff's camp. If anything, it's the apology that drives down the value of the case. They've done studies on that in medical malpractice. For example, if the hospital or the doctor get to the patient's family quickly and apologize, they've shown that it's easier and more cost effective. They get a better settlement because they've taken that sort of moral acknowledgement. The moral acknowledgement's been done. You've checked the box. There's a moral component to litigation in some situations where you're at fault because you're not going to have a trial. And since you're not going to have a jury pointing a finger saying, yes, you did wrong, you need to do what the jury would effectively do and acknowledge the wrongdoing. And clients don't want to do that. But I know they don't want to do it. It's human nature not to want to do that. That's very common. But doing that going to that sort of better place is actually very helpful for the mediation process. It doesn't have to be a long one. It doesn't have to be a huge mea culpa. Okay, but it does need to be scripted, and it does need to be rehearsed, and it does need to come from the client. I mean, apologies from lawyers they don't carry much existential weight. I don't mean to burst your bubble here, but that's a fact. Those are people who are paid to say what they need to say because there's a purpose to it. If it's coming from the client, it's far more authentic. If the client makes it authentic, and that's the other piece of the pie, is it can't be like perfunctory. You got to pretend like you mean it. You got to act. If you don't really mean it, you got to act like I mean it, because a hollow apology, a bad apology is worse than no apology. So what I've done in the past is when I've had a case where I thought an apology was appropriate, and it's not every case, because some cases are hotly debated. Some cases I don't have anything to apologize for. I didn't do anything wrong. But if I know there's clear liability, I know I breached the contract, I know I'm at fault, admitting it is just takes a lot of heat out of the room. It makes it easier to get a deal done. Trust me on this. So script the apology, rehearse the apology, have your client say, if you're the lawyer, have the client say the apology in front of you. Does it sound good to you? Then go with that. And tell them not to improvise, because in the day of mediation, particularly if you're a defendant, you may hear something in the opening that gets you hacked off or annoyed or sideways, and maybe you lose your head a little bit, and then you don't do the apology that you were supposed to do. You do a different one. That's not always a good one. So you're going to script it. You're going to stick with the script. You're going to tell your client, no matter what happens, this is the apology that we're giving. We're not going to deviate from the script. All right. Unless you get a really sophisticated client who can think on the fly. And that's not a large cohort of clients, because even the smartest clients, when they get mediation, can say dumb things. Trust me. I've seen it happen lots of times. Because just because they're business savvy doesn't mean they're litigation savvy. I've seen plenty of smart people say some really dumb things in mediation. So you want to script it when your client's talking and offering up an apology, but I think it's very powerful. Okay, so opening session. Let's talk about some general guidelines for plaintiff's counsel and defense counsel, because I see some cases go off the rails during the opening session. I just shake my head going, why did you say that? That's not helpful. That's not going to get the other side to help you. If you're a plaintiff, what do you want to have happen? In most cases, we're talking about money. We want the other side to give us all the money they could possibly give us on the day of mediation, correct? Right? We want to squeeze all the juice we possibly can out of them, and then even some more if we can. So why would you be focusing on past insults, indignities, things that have gone wrong in discovery, fussing about something that happened 6 months ago in a deposition, just what I call petty indignities that have happened along the way, or fuss about how long it took to get mediation scheduled. How is that helpful? How is that helpful? The first thing you say out of your mouth is, well, we're finally here. It took forever and a day. I'm not really happy it took this long. Why would you say any of that? That's just saying that there's some dilatory conduct on behalf of the defendants and foot dragging. And that may be the case. Maybe they were foot dragging. Maybe they had good reasons for not coming to a mediation, but you just didn't know what those were. But it doesn't engender any goodwill with the other side if you start carping about what essentially is their bad behavior, or implicitly suggesting that they're engaged in bad behavior. That doesn't engender them to want to write you a big check. And so it's not an adversary proceeding. You're not trying to score points in some sort of positional debate in front of a jury. You got to get your trial lawyer mentality and shove it aside. You're not trying to score points. You're not trying to beat them down. You're not trying to make them look bad, because there's no arbiter. There's no decision maker. There's no jury. The person who's the jury is the person that you're talking to. That's your jury. And that jury is either going to vote to pay you money, or they're not going to pay you money, or they're going to pay you a little or a lot. That's who you're trying to impress. That's who you're trying to convince to pay you money. There is no jury. So your statements are necessarily intended to get more money, or they cause the other side not to like you so much. And plaintiffs' counsel sometimes forget that. Stop talking when the other side's not listening. If your opening session doesn't seem to be gaining any traction, if people are looking in the other direction, making funny faces, stop talking. All right. If the defendant or somebody starts crying when you're talking, this can be on either side. If someone starts crying while you're talking, you need to stop and let them have a moment, get a tissue, take a break, whatever it is, rather than just sort of plow through. You need to have a little emotional intelligence, a little emotional awareness about what's going on in the room around you. And the other thing to do is make sure you find out who the paycheck is. Who has the checkbook? Because if you're a plaintiff's attorney, you're talking to the defense attorney, you're talking to the wrong person. The defense attorney's not writing the check. Someone's writing the check. Find out who has the checkbook in the room. You can, if you don't know, ask in a few minutes of mediation. Get the introductions. Who is this? Okay, who is this? Who's writing a check? If you should be able to figure it out pretty quickly. That's who you want to talk to. And then let the other side know this is a good time to settle, that you're prepared to settle. We want to settle this case. Create an air of optimism about the process. Don't leave it on a sour note. Leave it, make it, we're optimistic. We think we have a good chance of settling this case. Let's see if we can get this thing done. That's what the other side wants to hear. So give them what they want to hear. If you're on the defense side, no whining or carping about prior events again. Okay. No discussion about summary judgment or sanctions. No plaintiff or plaintiffs, no actual litigant thinks they're going to get summary judgment entered against them. If the plaintiff's attorney thinks summary judgment's a realistic possibility, he or she is going to price that into the valuation of the case. Talking about summary judgment arguments or talking about threats of sanctions goes nowhere in the plaintiff's ear, because the plaintiff doesn't believe that's ever going to happen. Otherwise, his lawyer would have told him that already. And sanctions are that's just a poison pill. We don't pay for sanctions. I mean, how many times have we dealt with sanctions? Sanctions motions go away if we settle the case. We all know that. There's pretty rare when I settle a case where the sanctions issue is still alive, right? We just don't do that. So why would you bring it up? That's for another day. That's for another day. All right. Pay attention to the claimant, not the lawyer. Pay attention to the claimant, not the mediator. You don't need to look at me when you're doing your opening session. Express optimism. Introduce the notion, particularly if you're a defendant, that reasonable people can differ as to the value of the case. There's no one number. There's a range of numbers. There's a range. Reasonable people can differ. I always like to say, when I was a defendant, I would say things like, we may have a disagreement as to the severity of the settlement value of your case, but there's no disagreement that you were injured. There's no disagreement that you were in serious pain. There's no disagreement that you've suffered a horrible loss here, and you're entitled to be compensated. All we're really trying to do is figure out what that number might be, and that's not an easy thing to do. And just admit that, right? Sort of admit that the decisional process, the decision-making process is difficult. It's not easy, but we're here, we're focused. I always like to tell the plaintiff that there's a lot of people that have been looking at their file, even though there might just be me and the claims representative and my client on the defense side. I always let them know that a lot of people look at this And while we don't necessarily, we might not reach an agreement as the ultimate number today, I want you to know a lot of people have looked at your file and have paid attention to it and considered it. And people like to hear that too. And it costs you nothing to say. It sets the right tone. You want to create, if you're a defendant, you want to create goodwill in the eyes of the plaintiff, because the plaintiff is going to be inherently suspicious. If they've watched television or the movies, they have an idea about what defense counsel looks like and sounds like, and it's not flattering, right? I mean, we've seen television shows and the movies, and the defense attorney is snarky. The defense attorney is mean-spirited. The defense attorney is not affable and a friendly fellow or lady. And so they have these sort of cultural stereotypes built in when they come to the mediation. And then you're either going to fulfill that stereotype by being snarky and mean-spirited, or you're going to bust that stereotype, which is going to be a big eye-opener for them. And you're going to engender a bunch of goodwill. And you say, Dave, why do I care about goodwill? I want to scare and intimidate them. That's a strategy. That's a strategy. Scare, frighten, intimidate. That's a strategy. I don't think it works very often, because they got their own lawyer. They got their own team. They got their own thing going on with their lawyer. Their lawyer's not going to let them be bulldozed. Most people don't take very well to intimidation and scare tactics. So I believe, you get more flies with honey than you do with vinegar. And so what I like to do is build goodwill in the relationship with the plaintiff and the plaintiff's attorney. I build goodwill with the plaintiff's attorney throughout the course of litigation by being a reasonable fellow to deal with. And then I'm trying to be an affable, decent person in the opening session, because I'm going to mortgage that equity in the relationship. I'm building equity in the relationship, and then I'm going to mortgage it at the time of settlement. I'm going to give you a little bit less than you really want, but you're going to take that money because I've been a decent fellow and I've treated your client well and I've treated you well, and you don't feel the need to continue to prosecute the case for a few more shekels. I'm going to mortgage the equity in the relationship. But if I don't have any equity in the relationship, there's nothing to mortgage. And I'm a big believer in that. I think it's hugely valuable to create equity in relationships, right? And then mortgage that equity at the time of settlement. And the other thing to remember if you're a defendant is time is the plaintiff's kryptonite. No matter how bad your case is, no matter how many weaknesses you have, no matter how much exposure there is, time is the one thing plaintiffs don't like. Plaintiffs and plaintiffs' attorneys, particularly on contingency fee, don't like time. Time is not their friend. Waiting and waiting and waiting for benefits. Some plaintiffs can afford to be patient, but most can't. So if you stress the fact that if you don't have much to talk about, if you don't have much at all in the way of good defenses, and you got a bad case, you still can stress the fact that if we don't get this case settled, it's going to take a long time to resolve. That's just the way the process works. And that time can be used by you and later by me as the mediator as a way of getting the plaintiff to a position where they're prepared to settle, because they don't want to wait the months and years that the judicial process is going to take. And so that's always sort of in your hip pocket if you're a defendant. Remember that time is the plaintiff's kryptonite. Okay. So those are a handful of suggestions for opening session. I think you should incorporate into most of your mediation sessions. Now, the thing I'll tell you about opening is there are times when you got to throw out the script. It's like oral argument. If you ever do oral argument in front of the appellate court, you've got your 5 or 6 bullet points that you want to cover that are your issues on appeal and the key facts and issues, but you get questions from the bench that just seem to come out of nowhere. And that can happen in mediation. And so sometimes if you get, like, for example, if I've been in cases where the plaintiff was hyper aggressive and snarky in the mediation process. And so what I did was I went super nice. I went super cordial. I went just the opposite. So there was a stark contrast to what he or she was saying. And hopefully that would be picked up on by the plaintiff.
Yeah, hang on just a second.
Himself. And the plaintiff himself then, plaintiff himself or herself then has to sort of look back and gauge their own conduct and say, well, maybe what I did there was a little bit out of line because Henry's acting completely differently from me. So I think that's one thing you can think about is, can I flip? Can I flip the script a little bit? Does it make sense for me to go off script and react in real time to what's going on here? And sometimes you need to do that. So don't get wedded to your script if you're in opening session. If it doesn't feel right, if it doesn't seem right, if it's not going anywhere, change directions. One time I had a case, and I think I said something that the plaintiff found offensive. I didn't know what it was, but I just said, she looked at me with a real sour look, and I said, I think I may have said something that's bothering you, that's offensive, and I don't mean to do that. Can I ask you, did I say something that was problematic or offensive to you? And I don't like to know. And then try to make it, on a human level, like we're acting as normal human beings here. We're not lawyer opposing party. We're human beings. And so I try to be emotionally aware, and that's not easy for me, not easy for a lot of lawyers, but we got to try to be emotionally sensitive to the situation when we're in the room with the other people. In the next session, when we come back on the 13th, we have one more half an hour today, but I wanted to highlight that in the session on the 13th, which is the next session we're going to have, we talk about dealing with multiple defendants and insurers. When you've got multiple defendants on one side of the case and sort of the special problems that get created in that scenario, that's one of the topics we'll be dealing with next time. So that's enough. That's section 5. Now we're turning to section 6 today, and section 6 is mediating the business divorce. And I like mediating business. I call business divorce is where the parties know each other in advance of the mediation. It might be a professional liability claim. It might be a real estate deal gone bad, a shareholder dispute, anything like that, where the parties have known each other, done business together in the past. Some have some familial relationship or business relationship, and now they need a divorce. They need to separate. And so those kind of cases raise some special challenges because the parties do know each other. In an ordinary tort case, they don't know each other before the accident or before the incident. So you don't have this sort of built up animosity, and you don't have this sort of built up history. So we got to treat those a little bit differently than we do other cases. They say, well, it's just business. No, it's not. It's not. Even in construction cases, even in cases involving maybe it's a bank after a lender, a lender after one of their debtors, and they don't like the way the debtor has behaved. I mean, it's so funny. You hear banks talk about, well, if this guy just communicated a little bit better or treated us a little better, we wouldn't be in this position. They even something is sort of you think of it as sort of corporately sterile, like a bank or a lender or some large financial institution. There's a human being on the other side of that file, and that other human being has a sort of moral judgment about the other side's behavior. And so behaving well in their eyes makes a difference to them. So it's not just business. It is personal. Many times it is personal, and you have to sort of figure out a way to navigate that. You got to identify it, and you got to sort of, if you're the mediator, you got to sort of navigate around that and make sure you get back to, yes, this is about money now. It's about finances. We're not going to fix your relationship. I know this guy used to be married to your sister, or this guy used to be a good valued business partner of yours, and now they no longer are. And I know they've, tortiously interfered with your business. You got to push past all that and say, okay, what is the business solution? What is the economic solution to this problem? Unlike most litigation, the parties know each other well. You need to expect anger and upset along the way. Anger and upset are understandable. You need to expect it's going to happen. You need to tell your client going into the mediation, the other side's likely to say something that's really going to hack you off, and you're not going to think it's true, and you got to let it wash over you. You got to let it wash over you. So you got to prepare them psychologically in advance and say, you're going to hear some things you're really not going to like. You're going to hear some things that you vehemently disagree with. And if you don't, great. Maybe the other side's not so snarky. Maybe the other side plays it low, plays it chill, plays it down, which is what you hope that they do, rather than be inflammatory. But there's some lawyers that just can't help themselves. They just insist on being as inflammatory as they can be because they're not really mediation advocates. They're trial lawyers who are stuck in a settlement mode, and they don't like it. And if you're a trial lawyer and you're stuck in settlement mode, you're probably not going to be on your best behavior. You're probably not going to be doing. You need to think like a mediation advocate, and that's an existentially different way of being. It is an existentially different set of skills because mediation doesn't turn on the application of fact to law. It doesn't turn on procedural nuance. It doesn't turn on your ability to manipulate a jury. It doesn't turn on your ability to dismantle an expert. All those things that we do as trial lawyers have virtually no application in the mediation process. It's a totally separate animal. And some lawyers get that and some lawyers don't. Some lawyers can transition, others don't do it so well. But it can be learned. It is an acquired skill. Some people come to it a little bit more quickly, but ultimately, hopefully over time, you'll get there. And that's really what this whole Mediation Mastery Series is about. It's about for seasoned lawyers who want to become better mediation advocates. And it's for new lawyers who need to know everything there is to know about mediation in a short period of time. And so we try to cover all the rules and all the things you need to do and the best practices in one 5-hour setting. And that's what we're trying to do here. And I think when we talk about mediating business divorce cases, it raises all these issues because it makes you have to be the best mediation advocate you can be in a business divorce, because you're going to be challenged in ways you otherwise wouldn't be. Like if you're doing insurance defense, your insured normally isn't challenging you in the mediation. They're kind of just there because it's the claims representative that's writing the check. So the defendant themselves is pretty, that's an easy relationship to manage because they're not really doing or saying very much, right? Right. But in a business case, you may be in a business divorce mediation where your client's now all over you, beating up on you. You put me in this mess. You've got me here. I don't know why I'm in here. You told me this was going to be a good case. You told me this. Of course, they didn't read the entire letter, right? They remember what you told them. They have selective memory about the things that you said. And so you might be in the crosshairs of their ire during the mediation process, which doesn't always happen in other kinds of cases. And so you got to be prepared. And so managing your client's expectations becomes hugely important going into mediation. Get to the real numbers immediately. Force your client to deal in reality. In business disputes, we don't have pain and suffering. You don't get aggravation damages in business disputes. It doesn't happen, right? Well, all the time it's not compensable. Stop talking about it. Force your client to focus on what are the real numbers here. And the sooner you can do that, the sooner you get through this emotional hoo-ha, say all the hassle, all the inconvenience, all the back and forth, all the deposition time, all the downtime, none of that's compensable. I've actually had plaintiffs come to me and bring me their damage theory and write down in the column, time spent in deposition, court hearings, 15 hours at $100, $150 an hour, and put it as an item of their damage. I go, what are you talking about? What is this number? Well, the client wants to get it. Well, you should have said no to the client. Why are you giving that number to me for me to take to the other side? It makes me look dumb and makes you look dumb. Oh, we didn't say that, but that's what I'm thinking. But I'm not taking that number to the other side. That's just silly. I mean, I will if you force me to, but that's a really bad idea because it makes you look like you don't know what you're talking about. So getting client control over the real numbers is really important. Don't lowball the costs. I can't tell you how many times the budget has been inadequate. Business litigation is ridiculously expensive because you can't anticipate what the other side is going to do. If they give you discovery easy peasy, it's not so expensive. But if they fight on everything and you got to file multiple motions to compel, it's really expensive and you can't predict that. So you got to factor into your budget a couple motions to compel, defending and prosecuting, a couple motions to compel. You got to assume there's going to be some haggling over timing of depositions. You're going to have to assume there's going to be some fussing about third-party subpoenas. All that kind of stuff's very hard to estimate, very hard to estimate. So I always create a very fat litigation budget. The client doesn't get upset if you're under budget. It's been my experience. Under budget is not a problem for the client. Now you say, well, I'm going to spook him if I give him the ugly number. Okay, well, let's have a conversation about economic reality. If your client's not engaged in economic reality, you got to ask yourself, what am I getting myself into here? Because I don't want to get in federal court and run out of money. That's bad because sometimes the federal court won't let you out. State courts are more liberal about that, but I've been in federal court and it hadn't happened to me, but it had to my partner where he's in federal court on a patent suit and his client ran out of money. And he wants to, my partner wants to get out and he can't. Middle district won't let him out. Now I thought there were rules against involuntary servitude, but apparently they don't apply to lawyers because you can be held to work for free. So I always want to have an economic reality text with my client, and I always have an evergreen trust account. So I don't set myself up for failure economically in the case. I'm not a credit card. I'm not financing my client's litigation. If you choose to do that, you need to do that with your eyes wide open. Maybe you don't have the luxury of picking and choosing your clients. You take whoever you can get. Well, be mindful of the money because ultimately at the end of the day, the biggest problem you run into from a legal malpractice standpoint is collection. The number one cause of legal malpractice cases across the United States is a collection action. The collection action gets filed to collect your fee, and what you get is a counterclaim for malpractice. That's the number one cause of legal malpractice. So when people talk about getting a budget and getting the case funded correctly and getting a retainer, all that is by way of ensuring that your client has the bona fides, the economic bona fides, to go forward with this litigation in an economically responsible manner. And if they can't do that, then you probably better figure that out pretty quickly because business litigation gets spendy in a hurry. Always schedule 2 mediations, one early and one late. Always schedule 2, because you want to be able to give your client the opportunity to get out quick and cheap before we have a lot of sunk costs. Sunk costs become a big problem in business litigation. People think that they're stuck. They've invested $100,000 in a case it's only worth $100,000. So they feel like they got to go on. No, they don't need to go on. They need to end it. They made a bad business decision and they need to cut it off. That's a very hard thing to do. But that's what I do as a mediator. That's my role. I was telling them, you made a bad business decision, bring this litigation. We're not settling sooner. So give them the chance to settle sooner. Give them the chance to get the case resolved before there's a huge amount of money being expended. So have a mediation within 90 to 120 days of joinder of all the parties. Then have another one later in the discovery period. But don't have your second mediation, or your first mediation for that matter. Don't have your first mediation at the end of discovery. Because if you go to mediation in a business case, oftentimes you're going to find out information you didn't know. If you do the mediation, that's true of almost any mediation, but particularly in business disputes, you find out there's a witness who's important. You find out there's a defense or a cause of action. Maybe there's even another party you need to join, right? Or Fabre in or something like that. So if you have the mediation at the very end of the discovery, you may not have time to react to that information. You may not have time to amend your pleadings. So I always recommend the second mediation be, maybe 2 or 3 months before the discovery deadline. So you have time to react to the new information and send out subpoenas or get a new deposition set or whatever it is. You'll sometimes find case management orders where they set the mediation deadline at the very, very end of the case. And that's just a bad idea. That's not a good idea at all. There's no reason for that. The courts do it because they don't care what the timing of the mediation is. It doesn't really matter to them how much money you've spent before you go to mediation. They're not keeping track of what the budget is. They're insensitive to the ebbs and flows of your client's finances, of their personal and financial needs. Courts are insensitive to all that. All they want is to say you went to mediation at some point. They put the mediation deadline at the end of the case because they think, well, that's just sort of where it should be. That's because no one's ever told them it's a dumb idea, because they're federal court judges or state court judges, and you can't say that's a dumb idea, Judge. You have to just take the order as you get it. But the reality is, the data shows that if you mediate earlier, you have a better chance of settling the case because you avoid the sunk costs. And you also avoid some of the toxicity and hatred, because over the course of a business dispute, I'm guessing the parties are going to hate each other even more than they did before, right? I mean, litigation is toxic. So the toxicity is going to increase over time. There's going to be more hard feelings, more upset, because you'll be taking pretty extreme legal and factual positions that might not comport with reality, but you need to for legal purposes. And so it gets harder to settle the case sometimes because there's so much animosity that's been built up. Whereas if they can get them a clean break early in the dispute, I think you have a much better chance of resolving the case. So have 2 mediations. That way, if you need the second mediation because your case isn't going the way you want it to, you've got that second mediation already on the books. You don't have to come asking for it. And that's another thing. You don't want to have to come ask for a mediation late in the case because the other side's going to smell weakness. But if you already have planned for a second mediation at the beginning of the case, then it's like a free spin, right? There's no tell. There's no tell. So I think setting 2 mediations is really huge. Nobody does that as a matter of principle. I mean, courts don't do it. So lawyers need to do it. And every time I suggested 2 mediations, when I was in private practice, whenever I suggested 2 mediations to the other side, I said, that's a really good idea. Yeah, it is a really good idea because you might need it. You might not want to ask for it, or I might need it, or we both might be tired of this litigation. And both of our clients may be looking for an off-ramp, but neither one wants to admit to it. So having that second mediation in your hip pocket is a really good idea. If you decide you don't want to go for whatever reason, you don't have to because you already had the first mediation. The court's not going to make you normally go to a second mediation. Sometimes the court does that. The court can order you to go to a second mediation, but normally they'd leave you alone. Once you mediate once, that's enough. If I was a circuit court judge, I'd make you go to mediation 2 or 3 times because I know that litigation objectives can change. People who are hell-bent on litigating in the first 2 or 3 months of the case lose interest, or maybe something changes in the marketplace. Maybe that real estate's not so valuable anymore. Maybe that development plan doesn't really need to happen. Maybe that trademark isn't as valuable as you thought it was going to be. Maybe that copyrighted material just doesn't go like we thought. Maybe it's just our business objective has changed. Maybe we need to wrap up the litigation because we're selling our business and we need to tie up this litigation as one of the loose ends because the acquiring company doesn't want to buy a lawsuit. So there could be a host of reasons. Maybe somebody's gotten sick. There's a whole host of reasons why people lose interest in litigation, not just finances, but lose interest, or there's no compelling reason to continue to defend or prosecute. And so litigation objectives can change during the litigation process. And the second mediation might be just what you need to deal with the reality that the case is not the same as it was when it first came in the door. And so I heartily encourage you to do second mediation as a standard thing in your business disputes. In business litigation, oftentimes we have non-economic terms that become important. We may have non-competes, non-disparagement, no trespass. We may have arguments over who's going to do business in what territory, or what products we're going to sell, or who we're going to contact, or anti-solicitation provisions. It could be a whole host of non-economic considerations that go into a business case that we don't find in ordinary BI litigation. My rule on that is, my general operating principle on that is, we put those toward the end of the day. We really try to get the money straight first, and then we worry about that other stuff later. If we get too caught up in the weeds in the non-economics, I think sometimes we get sideways with ourselves. Sometimes we can talk about those things in parallel because sometimes they're linked, right? How much money I'm willing to pay depends on the non-compete that you're forcing me to sign affects how much I'm willing to, accept. So those things are sometimes linked. But as a general rule, we put the non-economic things on the back burner for later in the day. The other thing I want to talk about is the attorney's fee myth. No one's getting their attorney's fees paid. I mean, I have a statutory claim for attorney's fees. I get fees under the contract. No one's paying your fees. Now, they might be priced into the settlement value, but no one's paying your fees, and nobody gets fees. All right. And even if you prevail in litigation, your client needs to know they're not going to get all their fees back. They think that they're going to get their fees back because the lawyer doesn't tell them. You're not going to get all your fees back. Because first of all, you're going to have a fee hearing. And if you have a fee hearing and you're arguing about the amount and not entitlement, you don't get your attorney's fees for arguing about the amount of fees. So you're going to spend fees chasing fees. And, you get into this sort of minutia of fee recovery, which the clients don't really want to hear, but we lawyers know. That, gets to the point where you're saying, well, if I have a fee claim for $100,000, if I got back 80, I'd be doing huge. If I got an award for 50 or 60, I'd be doing really, really well. And if I got paid half of my award, I'd be doing pretty well. So you need to disabuse your client of this fee myth, this idea you're going to get made whole. It's not going to happen. And good business litigators know that. They know that. Over the course of your 30 or 40 years as a business litigator, how many times are you actually going to get all your fees or a big chunk of your fees paid? Almost never. Almost never. So you need to disabuse your client of that notion right off the bat. Say, listen, yes, we have a fee claim. We're entitled to recover fees. But going into this, you should assume your fees are not going to get compensated. If you assume that going in, then you're coming at it from a more realistic viewpoint, I think. Okay. Remember, when we get and now we've got a deal that's got economic and non-economic terms. The mediator cannot be the scrivener of the deal. So it's really important that the lawyers draft the deal. In the old days, mediators started drafting, and new ethics rules say mediators should not be the one drafting the deal because they may be inserting language that one side or the other doesn't want or raises issues somebody didn't want to raise. So as a mediator, I stay out of the drafting process. Now, I'll offer you solution for language. I may have some helpful language. I may offer it just by way of saying, hey, what about this language? But I won't draft it. I won't insist on it. I'll be very careful and sort of balanced in my approach when I come up with language. Like if someone says non-disparagement, I'll say, well, let's make it mutual non-disparagement. Or if we have carve-outs for privacy issues or confidentiality, we'll talk about those carve-outs. But I'm very loath to get my hands on the word processor while we're typing out the deal. I think that's pretty gosh darn important. So if we're doing a business settlement, we have non-economic terms. We need to make sure we keep good notes during the course of the mediation so that when we get down to drafting, we remember what those non-economic terms are. Because sometimes when we're talking about the money late in the day, we can forget what are those non-economic terms that were important to my client. So we got to go back down through our list. All right. The other thing I would say about business disputes is I really like doing those in person. I like having that physical proximity. For some reason, I find it much more compelling if I've got all these folks in the same room, I use milestone reporting here in Orlando if we need office space and no one has it. But I like to have conference rooms that are separate, but not too far apart. But I like them separate so obviously we can't hear each other, but I like to be in the same floor. And I want to be in relatively close proximity. So in real time, I can get done talking to you. In 10 seconds, I can be in the other room talking to them. I want that. I don't like doing it by Zoom. Zoom, you just don't get that emotional commitment. I think you lose something in the process when you do these business disputes remotely. It's too easy to get tuned out, to say snarky things. It's harder to say snarky things when someone's just a few feet away in the other room. It's just harder to do that. So I think the physical and being fit and they're physically present, so I've got their attention. If they're on a Zoom call, they might be looking at other things on their computer, paying attention to other things, get distracted, not focus on the problem. So I really like having them sequestered in the mediation, in the old way we used to do it. Just everybody there in the room, working the problem. I find in business disputes, that's really helpful. And I've had a number of lawyers tell me, they said, Dave, if we had done this by Zoom, I don't think I would have got my client's attention. I don't think I would have been able to push them to the place I want to push them. And that's true too, is that the studies show that to the extent that I'm an influencer during the mediation process, my ability to influence your client to take the money or to offer more is enhanced by my physical proximity. So people will take instruction from somebody who's physically present or take guidance or suggestions from someone who's physically present. But if you're remote and if you're online, if you're way, way, way far away, which is effectively you are if you're online, then the power or the persuasive value of that speech, of that talk, of those thoughts diminishes. So there's a certain stickiness when we're physically present that I, as a mediator, can use to my benefit to get you to the place where I need to get you to get the deal done. So I think being physically, and if you're all relatively, you're local and it's not a big travel hassle, please try to get all together in the same office building for your mediation. Use a verdict form to temper your client's expectations about wild theories and non-economic damages and things of that nature. So this is what the jury is going to have to consider. This is it. Did they breach the contract? Yes or no? What are the damages for the breach? Right? Show them what a verdict form looks like. This is what the jury has to decide. This is what we're mediating. These numbers are what we're mediating here. Okay. And no claims for compensation due to the hassle of mediation. Be very clear on the recoverable damages versus the nonsense and say, well, we can get punitive damages. Really? How many times do people in business disputes get punitive damages? Not very often. Not very often. So until you've got a punitive damage motion in Florida approved by the court, that you actually got that issue in front of the jury, you don't have that issue in front of the jury. So don't talk about punitive damages in front of your client because no one's hardly paying punitive damages during a mediation. I can't remember a time when I settled a case where there was a punitive damage component. If there is a little punitive damage exposure, it's priced into the settlement because then they pay a little bit more on the compensatories, right? It's priced in by the defense if they see there's some legitimate punitive damage exposure. You just have to be mindful of that. Okay. What else can I tell you about mediating a business dispute? I think the idea of done is really important because if you're a relatively successful business person, you got other stuff going on. You want to be looking forward. You want to be doing the next deal. You want to be working on business opportunities, taking care of your business, your family, et cetera. And so one of the advantages I have in business litigation is I have this concept of done. You're over and done. You can end this today. And then the other thing I always tell the litigants, I say we're 20 or 30 or $50,000 apart. We've been mediating for 6 or 7 hours and we're 50 grand apart and we can't seem to bridge this gap. And I say to one side or the other, I say, is 50 grand really going to make or break you 10 years from now? Are you going to care? 2 years from now, you're going to care if you're still litigating this case and you've pumped another $250,000 of fees into this thing. You're going to care 2 years from now that you didn't spend the 50 or you didn't pay the 50 or didn't give the 50, right? And so if I can focus on done, that becomes really important to some folks. If they're sophisticated business people, they got some stuff going on, they want done and over. And ultimately, that's the ace in the hole that I have in my pocket when I'm mediating those kinds of disputes. All right. A couple other things. Cultural differences raise their head in business disputes in ways you don't see in other kinds of litigation. And that, boy, we could spend months and years dealing with that. That is a hard problem. I will just tell you that is a hard problem. If I'm mediating with Indian, Pakistani folks, that's different than Germans and Swiss. They negotiate differently. Germans and Swiss are usually not keen on haggling back and forth. 4, 5, 6 moves, not something they're interested in doing. And you say, well, these are cultural generalizations. Yeah, they are. They're just generalizations, but sometimes these generalizations are sort of true. You kind of got to be mindful of that. That they don't navigate the mediation process the same way. Some cultures will kind of feign like they're walking out. They say they're about to walk out. The walkout is part of the deal. They're not really done, but the walkout is a signal that they need to do internally to placate somebody. All right. Or in their culture, walking out is important as a show of strength. Okay. And being respectful during the mediation process means a lot to different folks, and the language that you use. And if you have to use translators, oh my goodness, I can't tell you how important a good translator is, because I feel like I'm in a real disadvantage if you're not a native English speaker. And I've got to be very careful with my language and go very slow to make sure that my message is getting communicated to the other side and that I'm understanding their message, and understand that we're going to lose something in the translation. We just are. We just are. And so we have to go slow in those kinds of situations. And we have to really rely on the lawyers a lot to get client control in those kinds of situations. Cross-cultural mediations are just difficult. The rate of impasse is very high. I will tell you the rate of impasse is pretty high in cross-cultural mediation. And I don't know what the solution to that is, because they don't, it's the same reason why cross-cultural marriages have a higher divorce rate. There's something about that that makes them not want to be able to do a deal as easily as you would if everyone shares the same cultural norms and values and language. So just appreciate that. You need to get quality translator. And if your mediator has experience in dealing with those cultures, that's important. I did a lot of work for in the hotel industry, and we had a lot of Indian and Pakistani owners, and I got very comfortable mediating in that environment. But that's just an example, and I don't speak Spanish, so sometimes when I have Spanish-speaking people, I'm a little bit of a disadvantage. Those are the sort of things you need to think about when you select your mediators. Is this mediator good in this arena? Do they have some subject matter expertise? That's another thing that's helpful in business disputes. Doesn't matter so much in other kinds of cases, but having some subject matter expertise, if it's intellectual property, if it's professional liability, some subject matter expertise can go a long way, because that mediator can offer some pushback. They can call it out and say, now, wait a second. You're trying to tell me they abandoned the mark? There's, how hard it is to prove abandonment in a trademark case. I mean, that's the sort of thing we can have a conversation about if you have some subject matter expertise in that area. And then the other thing I always stress in business disputes is I always talk about time, because trial is not the end of the day. In a business dispute, particularly if there's claims and cross claims, there's a risk of appeal. And so the thing I always talk about with the litigants is I talk about appellate risk. I mean, what's the risk that one or both sides in this dispute after trial is going to want to take an appeal? And if they've got some funky issues, some contractual interpretation issues, some statutory issues, they got something that's a little novel or weird or different, I'm going to say, well, then trial's not going to be the end of the day, because if you win out, if you crush the other side and get this big verdict that you say you're going to get, isn't the other side going to be highly motivated to take an appeal? Absolutely. If you get a defense verdict on this record with these facts and these issues, isn't the plaintiff going to say the judge got it wrong or somebody got it wrong? Probably, yeah. So I always make sure that when I'm in a business dispute mediation, that I tell the parties, I go, don't forget, trial's not the end of the day. And when you factor in when you think you're going to be done and how much money you think you're going to spend in adjudicative process, you've got to factor in the risk of an appeal, even if it's a 10% risk, a 30% risk, a 50% risk, whatever that risk is, and how much is that going to cost and how much time is that going to cost. And when I raise the specter of appellate proceedings, the clients take note, because oftentimes the lawyers haven't mentioned it. It's very common for trial lawyers in their discussions with their clients to forget to talk about what happens if we lose really badly. What happens if we win really badly? Win in a big way. If we win in a big way, that's almost a bad thing, right? I mean, if you got a case where the damages are between $1 and $3 million, and the other side is prepared to try the case, a $3 million verdict is a lot more likely to get appealed than a $1 million verdict. So a 1.5 to 1.7, 2.0 verdict is probably the sweet spot, because that's the one where they almost don't want to appeal, but it's still a good recovery, if you know what I mean. So I always think about appellate risk when I'm talking to my mediation participants in a business dispute. And when I mention that, I sometimes get that, yeah, I hadn't thought about that. That makes this deal now a little bit better, because if we don't get the case resolved, I'm looking at not just another year to trial, but I'm looking at possibly another year or two after that for any risk of appeal. And the clients routinely don't think about that, because they don't see it on television or the movies either. I mean, nobody goes to TV and watches television or the movies and then sees an appeal after a verdict. It doesn't happen. So those are some of the things I think that are helpful in thinking about mediating business disputes, and they are a different animal. I appreciate you showing up for this 5th and 6th session. Our next session will be September 13. We're going to talk about mediating with multiple defendants and insurers in their larger cases. And then we're going to talk about also mediating with not-for-profits and homeowner associations when supposedly money doesn't matter. So that'll be sections 7 and 8, and that'll be on September 13th. And if you haven't had a chance already, please go back and take a look at the sessions 1 through 4, which should be available on my website at henryadr.com under CLE Video Library. So thanks very much. And if you have any questions or comments, you can email me, dhenry@henryadr.com. If you want the mediation countdown form or the what is a mediation memo to client, email me at that same address, and I'll be happy to send you that form if it's not already up on the website. My website is currently under a little bit of improvement, so it might not be there yet, but I'll email it to you anyway. Or you can come back to the website in a week or so, and everything that I mentioned should be up there and available in the resource tab. So again, thanks for showing up, and I'll see you on September 13th. Take care, and bye-bye.